Welcome to Pinvest.Exchange, India's first real estate channel. Let's dive in the latest property news from Indian market. The Bombay High Court has ruled that a tenant company, once exceeding the 1 crore rupees paid up capital threshold, cannot regain protection under the Maharashtra Rent Control (MRC) Act 1999 after voluntarily reducing its capital. The court dismissed claims from Matha and Platt that the company's financial standing had worsened due to this reorganization, emphasizing that it still remained financially stable and capable of paying market rent. This financial ability is a key consideration under the MRC Act. The case involves Hamilton House, a property located in Ballard Estate, South Mumbai, and owned by Depe Global Shipping Agencies. Under the MRC Act, tenants benefit from protections against unfair eviction, rent control, and rights to essential services and repairs. The court made clear that a reduction in paid-up capital does not automatically restore a company's lost protections under the MRC Act. This decision is likely to have broad implications for similar situations where landlords and commercial tenants are navigating the complexities of rent control laws. The case centered on the eviction of Matha and Platt from Hamilton House. The landlord argued that the tenant had lost protection under the MRC Act as its paid-up capital exceeded the legal threshold. The tenant, however, contended that its recent capital reduction should reinstate its protected status. The court disagreed, ruling that paid-up share capital reflects a company's true financial worth, and once protection is lost, it cannot be regained. The court also noted that there is no provision in the MRC Act allowing a company to regain rent control protections based on changes in its capital after 31st March 2000. Senior advocate Haresh Jagtiani, representing the landlord, argued that a company's paid-up share capital rarely fluctuates and that once a company surpasses the 1 crore rupees threshold, it is classified as cash-rich. He further asserted that the company lost its protection on 31st March 2000 and its paid-up capital at the time of filing the suit is irrelevant. The court cited legal precedents, underscoring that once a tenant loses rent control protections, the landlord has the right to seek eviction. Allowing a tenant to regain these protections after eviction would undermine the purpose of the rent control legislation. In its judgment, the court overturned earlier rulings from lower courts in favor of the tenant, affirming the eviction as valid and ordering Matha and Platt to vacate the premises by 31st December 2024. This ruling sends a clear message to landlords and tenants alike, affirming that the core principles of the MRC Act remain intact and must be followed to retain rental protections. The decision also highlights the need for clarity in commercial lease agreements and the potential impact of corporate financial maneuvers on rent control laws. We value your input. Your feedback shapes our content. Thanks for watching Pinvest TV.